Thank you, Senator Bradford. You may present SB 1088.
All right, I'm doing SB 1088, which will amend the Public Safety Officers Procedural Bill of Rights, better known as POBAR, to provide that a violation of the Act shall not be the basis for reversing or modifying discipline if a procedural violation is deemed to be without a substantive effect. This harmless error rule, comparable to what is applied in judicial proceedings, would be determined by the administrative hearing officer or board or by an arbitrator. These violations include procedural errors, including the admission or exclusion of evidence, unless the error adversely affects the substantial rights of the officer to an extent that constitutes fundamental unfairness. Harmless errors, including technical errors that are not so damaging and prejudicial as to change the outcome of an investigation or a decision, and with consideration of the totality of the dispute, when evidence of misconduct is significant enough to outweigh a claim that an error was substantial enough to justify a change in discipline. SB 1088 applies a common legal standard used in virtually all legal proceedings, both civil and criminal, to POBAR. The California Supreme Court has already applied the harmless error principle to POBAR in reversing lower court rulings. This bill clarifies that the court's application of the harmless error rules is not applicable merely to the facts of that case, but to all police discipline cases in the state that fall under POBAR. POBAR provides law enforcement officers with an extensive list of rights, which has the effect of insulating officers from accountability when they are known to have committed misconduct. While POBAR should be, of course, be followed, technical violations that do not impair the rights of the officer often preclude agencies from addressing serious misconduct. The bill does not intend to encourage employees to engage in procedural violations. Inviting procedural errors runs the risk of losing the case and could make them subject to substantial civil penalties. Nor does this bill aim to take away rights afforded to officers. Testifying in support today is Barry Winograd, past president and National Academy of Arbitrators and lecturer at Berkeley Law School, and Ronald Yank, a retired law enforcement union attorney for 30-plus years and the past director of Cal HR under Governor Brown. They're also available to answer any technical questions, and I respectfully ask for aye vote, and I respect the fact that they've been here all day.
Okay, we're on.
Yes, you are.
I'm Barry Winograd, arbitrator mediator. I've been introduced by the chair. I want to say preliminarily, 8.5 hours plus we've been here. I've run a dozen marathons in my life. I've presided over hundreds of hearings, sitting all day in hearings. If I was wearing a hat, I'd tip it. Okay, you deserve it. And I wish the public could see the depth and scope of your probing of issues of public safety. With that said, I'm a member of the Law Enforcement Reform Study Group, along with Ron. That's a small group, 6 of us. We have, I think, cumulatively over 400 years of life-living experience. We're in our late 70s, and we're on the younger end of that group, right? It includes Joe Grodin, former Justice of the Supreme Court and a labor lawyer and a professor emeritus at Hastings. It includes Thelton Henderson, retired U.S. District Court judge of the Northern District of California, who previously was in the Civil Rights Division of the Justice Department. It includes Catherine Fisk, a professor of law at Berkeley. It includes John True, a former labor lawyer and former Superior Court judge in Alameda County. It includes me, and it includes Ron. Among us, we have probably about 200 years of experience in labor relations. After George Floyd was killed, we decided, well, what could we do? We got together, we said, our wheelhouse is labor relations. What can we do to help improve labor relations in California? And I note 4 of us have been union lawyers in our life. We did not want to abolish collective bargaining. We did not want to give all power to police chiefs. We are not at that end of the political spectrum. We decided we could come up with some pretty decent reforms, and we put together a package. And we thank Senator Bradford, for giving consideration to one of the most important pieces in this package, this, what we'll call this harmless error bill. It fills a gap in the POBAR, which now only has a very specific provision as to enforcement, and it allows for when this legislation, this act, is incorporated in collective bargaining agreements, which it is up and down this state, and when it is presented in arbitrations, as it has many times before me. Well, there was this technical procedural violation of the act. Therefore, this particular police officer should not be found to have engaged in wrongdoing. We're filling that gap. This is important for police accountability. It ends reliance on technical procedural violations that will excuse misconduct that is otherwise proven, where there's no prejudice, there's no loss of a substantial right. It is important for public safety because it prevents, creates a bar to reinstatement of serious wrongdoing when there's no prejudice in terms of substantial rights on the merits. It's important for transparency. It allows the public to see what is going on without burying wrongdoing behind some technicalities. It is important for unions. I am actually quite surprised that there are so many unions who have expressed kind of uniform opposition. When I am told in private, there are union lawyers who think this is great. They won't have to be representing some of the repeated wrongdoers who clog up their own calendar and attention. And by the way, there's no prosecution group that's in opposition to this bill. So that's an interesting fact all by itself. It is important to note that there are other remedies available, and I think that really sums up what I have to say about this, this piece of legislation. We thank you again for your attention and support.
All right, so when a police officer, deputy sheriff, gets off on, I'll call a technicality, a POBAR violation, it looks horrible to the public. After George Floyd and various other atrocious incidents that were visible to us all on television, there was a backlash against arbitration in general. Now, that's not so terrible for a winning union side because they can say, look, the arbitrator is like a judge. He, she heard it on the merits. We had a better case. We won. But when the officer gets off on a technicality, it looks like holy heck to the general public. Think about how, what the hell, Bill Cosby gets released from prison and the horror of the public to that. When the public thinks that there are dirty cops in our departments, there is a huge backlash. By the way, let me just give a quick example of a technical violation that would not allow a reversal in our situation. So there's a 12-month requirement. The department learns of a problem. They start an investigation. They've got a year to go ahead and bring charges. But because of police departments being understaffed, they send every cop they've got out on the street. The paperwork is late. It comes in 13 months. However, in this case, the officer knew, like in month 1, who all the witnesses against him or her were going to be. So because the charges were brought in 13 months instead of under 12, the officer suffered no prejudice at all, and that case should not be thrown out, and yet arbitrators have felt compelled to throw out such cases. In any event, back to the public backlash on the perception and the reality of dirty cops, from, you know, the George Floyd incident to the black jogger in an Atlanta suburb, et cetera. This is all over the media, word of mouth. Obviously, police officers are innocent ones. The vast, vast majority are not anywhere near the kind of victims of those who've suffered from police misconduct or their families and loved ones. Nonetheless, morale has just dropped like a stone. What you have is an incredible number of retirements resignations, you've got a much less interest in young, bright cookies that we'd want to be in law enforcement joining and applying for police academies. What does this mean? This means understaffed police departments, less professional police departments, and obviously less trust between the public on the one hand and police officers on the other. In a way, and as Barry said, getting dirty cops out of departments can easily be seen as a benefit to unions. They don't have to spend their legal defense money defending such officers, et cetera. I'm going to close with this bill, authored by Senator Bradford, does no prejudice to an officer if there's a POBAR violation, because he, she, again, in my 13-month versus 12-month, the officer knew the witnesses all the way, suffered no prejudice by virtue of the delay. Speaking on behalf of both Barry and me, we'd be happy to take any questions from any member of the committee through the chair, of course.
Thank you so much, sir. Would you mind stating your name and your and where you're from for the record, please?
Sure. All right. So my name is Ron Yank. I was a union attorney for like 30 years. I retire a couple of years. Jerry Brown gets elected, and Jerry Brown asked me to switch sides of the table and represent this state and him in collective bargaining against the unions that refused to close an MOU with Arnold Schwarzenegger. I told the governor I could do it only for a year because my family, and most important, my grandkids are in the Bay Area. And then 3 years later, I take a job with Felton Henderson trying to close the consent decree of the Oakland Police Department. So there was another job I held. I'm on my third retirement, but this one's going to stick.
Yep, but I think Ron only had 2 pensions. In recognition of Ron, he did not say that the unions he represented for 30-plus years were public safety unions, police and fire, at the state level and at the local level, all over the state of California. And there were few, if any, union advocates who had the breadth of practice and the trust in practice that Ron had. So I'll just add that in deference to my colleague.
Thank you very much to both of you for being here and testifying. Now let's begin with any witnesses here in room 112 in support of SB 1088.
Leslie Caldwell Houston for the California Public Defenders Association in support. Thank you.
Thank you. Do we have any other witnesses in support of SB 1088? Seeing none, now we'll move on to witnesses waiting to testify via the teleconference services, and we will take 10 minutes of testimony.
Thank you. If you wish to speak in support of SB 1088, please press 1, then 0 at this time. I have no comments in queue.
Thank you, ma'am. If you don't mind checking the line one more time just to assure ourselves that we've heard from all support witnesses.
Thank you. If you wish to speak in support of SB 1088, please press 1, then 0 at this time. I have no comments in queue.
Thank you, Madam Moderator. Having heard from all supporters, we'll now follow the same process and hear from the opposition. We do have 2 lead opposition witnesses. We have David Mastagani Jr., and I apologize if I mispronounced your name. I believe maybe in person? Oh,
I am on
over the line?
Yes.
David, are you on the line?
Yes, I am. Can you hear me?
Absolutely. Please proceed, sir.
Thank you very much, and good evening. I appreciate the opportunity to appear here today on behalf of PORAC. I'm a labor attorney. In fact, I studied labor law under Professor Winograd at Berkeley, and I understand the importance of procedural representation rights, which is why POBR is so important. My clients and I have worked with stakeholders and the leadership to address many of the concerns underlying this bill, including modernizing force standards, increasing transparency, and Senator Bradford's bill, which set a procedure for decertifying officers who commit serious misconduct. I'd first like to clarify what POBR does and doesn't, though. POBR primarily provides procedural rights during an investigation that largely mirror the rights that unions have. It's not about getting off on a technicality. It's about things like before an officer is questioned or interrogated, they receive notice, the right to get a representative, the right to record the interview, the right to use the restroom. It's also about due process, that officers receive a right to access their personnel file, review adverse comments, write rebuttals, obtain exculpatory materials that are withheld from an internal affairs investigation. These remedies are really modest, and they primarily deal with the admissibility and the access to evidence. The first remedy that you usually see is suppression. It's modeled after the exclusionary rule in criminal justice. Unlawfully obtained statements or evidence may be excluded where appropriate to cure a violation and to disincentivize agencies from continuing to have further violations. Secondly, it also provides a mechanism to obtain evidence improperly withheld. This is very important as administrative appeals often have limited discovery procedures and access to that information. I've successfully enforced POBR rights on several occasions over my career, and I can tell you, in none of those cases did a procedural violation result in a discipline being overturned. Most of the cases I've handled involved the suppression of officer statements where they were unlawfully interrogated without a union rep. In those cases, without exception, the court expressly allowed the agency to continue to pursue the disciplinary case, but simply prohibited the agency from using the ill-gotten statement. In fact, in all of those cases, the circumstances where an officer was interrogated without a rep and without notice on the spot, they were subsequently sent to internal affairs and the rights were afforded to them. And the subsequent statement in internal affairs is and was admissible, and the court allows the case to go forward, just like in a criminal case where evidence is improperly obtained. The other type of cases that I've dealt with involved access to material, and I, in fact, argued one of the seminal cases, the Sacramento Police Officers Association versus Venegas, the published Third District Court of Appeal decision that established that peace officers have a right to access adverse comments contained in their internal affairs files that are used to hinder their career path.
Mr. Mastegani, just to let you know that you're just about 2 minutes, and it's going into the second witness's time frame. I apologize. The second lead opposition witness, Mr. Ryan Sherman, is giving up his time or a lot of time that you may need in order to testify. So please proceed.
I appreciate that, and thank you, Ryan. This bill is also unnecessary because the Supreme Court ruled a long time ago in 1988 that it's an abuse of discretion to overturn discipline or even to suppress a statement in certain circumstances over minor violations. Supreme Court precedent is binding on every court in California, including on the administrative bodies. The court in that case laid down a but-for analysis when considering a violation and said that reinstatement is not proper where the employer would have reached the same conclusion without the POBR violation, and that's very consistent with all of my experiences. The court even in that case said that suppression wasn't appropriate when the officer's right that was violated was not prejudiced and it wouldn't be likely to have a future deterrence effect. And the court said also that suppression is appropriate in some cases where it's an effective deterrent. This bill would prevent a trier of fact from having the discretion to fashion a remedy for POBAR violations whenever the evidence of misconduct is significant enough, according to the bill, to outweigh the significance of the violation. This would create a perverse ends justify the means incentive for investigators that would be unacceptable in any other context. No one would support allowing police investigators to violate Miranda or Fourth Amendment rights just because the investigator believed the suspect committed a serious crime. The same applies here. In fact, the converse is really true. The more serious the matter, the more important it is for investigators to follow the rules and afford people their rights. This bill goes too far by eliminating the trier of fact's ability to exclude improper evidence and incentivizing interrogation violations by eliminating agency accountability. We should not be encouraging any law enforcement investigator to cut corners or to violate rights in any context. We need a culture that fosters officers affording rights. And Mr. Chairman, your bill SB 2 also obviates the needs for this bill because SB 2 provides a separate procedure to decertify officers who engaged in serious misconduct. Significantly, the POBR rights do not apply at all in the SB 2 decertification process or procedures. Thus, it's unnecessary to clutter POBR with a balancing test between the violation
Sir,
and
we're going to
the
have to
alleged
ask you
misconduct.
to close. You've been given Mr. Sherman's time as well, just about 2.5 minutes.
And that was actually my last sentence. I was just going to close with it. SB 2 already defines serious misconduct, and that process operates completely independently of POBR and the discipline process. And I thank you for your time, and I apologize for going over.
Thank you very much for your time. We'll now continue with any witnesses here in room 112.
Good afternoon, Mr. Chair, members. Ryan Sherman with the Riverside Sheriff Association, also in opposition, joined by the Police Officer Associations of Claremont, Corona, Pomona, Palos Verdes, Newport Beach, Placer County Deputy Sheriff Association, Upland POA, Santa Ana POA, POAs of Burbank, Inglewood, Arcadia, Riverside, LA School Police, Fullerton POA, and Culver City POA, all in opposition. Thank you.
Thank you very much. Do we have any other witnesses in opposition? Seeing none, we'll now move on to witnesses waiting to testify via the teleconference services. We'll take 10 minutes of testimony. Moderator, if you would, please prompt the individuals waiting to testify in opposition of SB 1088. We will begin.
Thank you. If you wish to speak in opposition to SB 1088, please press 1, then 0 at this time. Line 311, please go ahead.
Thank you, Madam Chair and members. Matthew Cyberling on behalf of the Association for Los Angeles Deputy Sheriffs in opposition. Thank you.
Thank you. Line 216, please go ahead.
This is Matthew Weasley representing the California Correctional Peace Officers Association in opposition.
Thank you. Line 326, please go ahead.
Mr. Chair, members, Shane Levine on behalf of the California Statewide Law Enforcement Association, the Fraternal Order of Police, California Lodge, and the Sheriff Employees Benefit Association of San Bernardino, all in opposition. Thank you.
Thank you. I have no further comments in queue.
Thank you very much. If you would mind checking the phone lines one more time, Madam Moderator, to assure yourself that we have heard from all witnesses in opposition.
Thank you. If you wish to speak in opposition to SB 1088, please press 1, then 0 at this time. I have no comments in queue.
Thank you, Madam Moderator, and we want to thank all our support and opposition witnesses. We'll now bring the discussion back to our members. Do you have any questions or comments? Perfect. Senator Bradford, would you like to close?
I want to thank my witnesses, both Mr. Winograd and Mr. Yang, for your expert testimony. I also want to appreciate the comments by the opposition, but the opposition's position is not new. It has been like that since almost the beginning of time when it comes to trying to reform and asked law enforcement to be held to the same standards as the general public is every day. And this is all that this measure does. It doesn't strip away any of the police officers' Bill of Rights. It just allows us, we've seen far too many George Floyd's, Rodney King's, Ron Settles, Sandra Bland's, officers who have blatantly violated their jobs, the badge in many ways as well, and go unscathed. And this is just holding officers accountable, just like you'd hold the general public. So this is all we're trying to do is treat everybody fairly, and law enforcement shouldn't be above the law. Again, this is not about stripping away any rights. If anything, I think those 99% of the men and women who put that uniform on every day and adhere to those guidelines would appreciate us kind of like improving upon the guidelines and making it clear on, I won't say easier, but a fair way of holding those who violate the rules of law and accountable. And this is all that we're trying to do with this measure, and I respectfully ask for your aye vote.
Thank you, Senator Bradford. I'd just like to comment that it was actually pretty, as a former teacher, I thought it was pretty neat to have a professor and a student here testifying at the same time. And in this case, or in this piece of legislation on opposing sides, but I think it's really neat to see a professor and his student going back and forth. It's pretty, I think it says a lot on your part as a professor. So kudos on that legacy. So do we have a motion? Thank you. We have a motion by Senator Kamlager. The motion is do pass, but first we refer to the Committee on Appropriations. Council, please call the roll on SB 1088.
SB 1088, Bradford. Bradford, aye. Chobog. Chogobog, not voting. Kamlager. Kamlager, aye. Skinner, Weiner.
We will leave that bill open for our absent members.